We're here to talk about an important update to Ohio law in March of 2025, 2903.216. If you feel motivated to get on your Googleplex machine and look it up, is a tracking law in the state of Ohio that was recently updated. And it relates to family law in a very important way that I think comes up a lot in my case, is that you should be aware of before you would embark on any divorce or dissolution track in your life. It has previously come up many of my cases that a spouse will want to track the other spouse during the pendency or immediately preceding a divorce action. Now, usually this will relate to a fear of infidelity or a belief that infidelity can be used in a divorce to benefit one side or the other, either on the division of property or in the division of parental rights. Sometimes it comes up when a parent believes that the other parent is engaged in alcohol abuse or drug abuse or some other nefarious behavior for which they have to track them. Or another common scenario that will come up is a parent will use a phone device or Apple Watches or a variety of things to track the children when they're with the other parent just because they don't trust the other parent. And I am here to tell you that now, under that law, once a divorce is filed, that is over. You are not permitted to do that. The law requires to have the tracked party's consent, and a divorce filing automatically revokes that consent. And this could lead to criminal consequences. Now, this is March 2025 that this changed. Hasn't happened yet in any of my cases, but I absolutely believe it could. And so let's talk through some of these issues so that perhaps you avoid an easy mistake for an aggressive attorney opposing you in a divorce case. Let's start here. Infidelity does not matter. It does not matter. It does not matter. It does not matter. Unless the other parent is having the infidelity in the room with the children, and I mean it exactly that way. Unless it is that, it doesn't matter. The court isn't going to divide property differently. The court isn't going to divide parenting rights any differently. It is going to do best interest for the children. It is going to divide equally unless equal is not equitable. That's it. So if you are tracking because you are searching for infidelity, just stop. It doesn't help you. If you are tracking for another purpose, like let's say we're talking about drug abuse or something similar to that, which might actually affect the best interest of the child analysis in a very significant way, still don't track. There is a provision in there that allows private investigators with appropriate authorization, law enforcement officials with appropriate authorization to do that tracking for you. If you need to, seek out a court order. And before you give me what I think is going to be the objection on this, well, if I tell him I'm tracking him, he's going to know it's coming. Let me remind you that an addict can't stop. They can't stop. They can't stop. If he is an addict, you could tell him, I'm going to drug test you on Friday, and he will be high on Thursday evening. That is an addict. So if he really is what you think he is, you're going to catch him at some point if you do it the right way. Don't set yourself up for an obvious argument against you. Don't undermine the ability to argue that issue because you have violated the tracking law. In addition, the children piece. I think that one comes up quite a bit in my cases because technology is so ubiquitous nowadays. Many people carry devices, many children carry devices that have an auto tracking device on them, the Apple IDs and the Life 360s and the various things that are out there that can do this job for you. Don't use them. When the children are with the other parent, you have to let the parenting time happen. If you take a risk and you track, you are going to attempt a contempt finding. In your case, potentially, you are also going to attempt law enforcement involvement, and a criminal conviction during your divorce case is not going to play very well. Again, I haven't seen it yet. This is a developing area of law. One of the exceptions, for example, is the vehicle exception. If you are the owner of a vehicle, you are allowed to track your own vehicle. And I can already see it coming. I have looked in case law to see if this has happened yet, and I could not find any. but I'm certain that there is a family out there where one spouse owns both of the vehicles and the other spouse is using one of those vehicles, and they think that will give them authorization to track. And maybe you're right, but I wouldn't take that risk if I were you. I would not track unless you expected that vehicle to be stolen, travel with the children across state lines. Then maybe it's worth the risk, perhaps, possibly, but I still wouldn't advise it. Let it go. Do not track, do not risk violating this law. And if you have any further questions about this issue, feel free to give me a call. My name is Eric Cherry. I'm at MP Weiss Law. Thank you.